Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Nasser Wright.
Your turn to the left.
This is Nazir Wright in 23 CF 321. We are here on a motion to reinstate bond. He was out on bond for a possession of carrying a concealed firearm, in which a firearm was under a jacket inside of a car. We have done depots on that. The officer said he can't identify who was in the car at this point.
Speaking to the mic for me, Ms. Dudley.
Sir?
Speaking to the
Yes, sir.
mic.
Yes, sir. The officer stated at depots that he could not identify who was in the car or identify any of the individuals or say who they were. There was no evidence that Mr. Wright had ever had the firearm, and actually one of the co-defendants stated that the front seat passenger is the one who told him there was a firearm in the back seat. He has violated bond allegedly by committing trafficking of fentanyl. However, the fentanyl found in the vehicle was in the back cargo area of the SUV. There were 5 people in the car. No one had the fentanyl. He arrested all 5 people and charged all 5 people with constructive possession. There is no evidence in that case that anyone exercised control over the fentanyl, had knowledge of the fentanyl, had dominion over the fentanyl. Mr. Wright is 17 years old. He has come to every court date this court has asked him to, even when there was a motion to get his DNA for a search warrant. He showed up from Georgia with his mother. He is not a flight risk. We are just asking that the bond be reinstated in this case.
What size bond are you requesting?
I think he was originally released on a signature bond, and we would ask for a signature bond or a reasonable cast of professional bond based on the facts of the cases and his age. And no, he has no prior criminal history at all.
So, Your Honor, Mr. Wright, his bond was revoked at first appearance because probable cause was found for a new offense, which is trafficking in fentanyl. 36.5 grams was found in the back seat of this vehicle per the new offense, where Mr. Wright was. there were allegedly, according to Highway Patrol, pills and guns being thrown out of the right front passenger seat when the car actually, if car flees from the Highway Patrol, once that car is stopped and disabled, there are also fentanyl, what's suspected to be fentanyl pills in the back seat where Mr. Wright was seated. According to the arrest report, probable cause has been found for a new offense, Your Honor. At this time, the state asked for him to remain with no bond as he has committed a new offense, trafficking at that, while he's out on bond.
Your Honor, if I may. The arrest report does not state it was found in the back seat. What it says is, it does not state that the drugs are found in the back seat. It says the drugs are found in the back cargo area of the SUV. It says that because Mr. Wright was seated in the back seat along with 2 other people, that they charged everybody with the possession of the drugs. As far as the items thrown out of the vehicle, they say that the front passenger threw the items out, which is not Mr. Wright. And as far as fleeing goes, Mr. Wright was not driving the vehicle. Mr. Wright, according to the report, was sitting in the middle of the back seat. There were 2 people with him, and that the items are found in the back cargo area of the SUV.
What's the differentiation with the cargo area in the back seat? I'm unclear about that.
I was using those interchangeably, Your Honor. The back cargo area to me
What do you
is
mean?
So
in the back
What do
seat
you mean the
within
back
reach
cargo
of-
area, like the trunk?
like the trunk area, yes, sir, of the SUV.
Okay. Well, that's not a trunk if it's an SUV, if it's just like a back.
Yeah.
Somebody explain it to me. You know what kind of a vehicle it was? Was it a trunk? That's what the defense just said. Is it a trunk?
Give me just a
They
second.
Or
are-
a back, or like a,
Just the back of the SUV, so not the back seat, behind the seats. To me, it doesn't matter either way. The law states proximity alone isn't enough to establish knowledge of being in control. The only evidence they had at the time, they said they saw a hand come out the window and they believe it was a front seat passenger who threw something out. Those are the allegations in that case.
understand that there are issues, evidentiary issues. Good defense counsel, you're pointing those out. I appreciate that. Let's go to trial and deal with these. These are very serious charges. Not only are they gun charges, but they're also fentanyl trafficking charges. They're extremely serious. Let's get this thing to trial and let's argue over what the facts say. For the time being, I think it's reasonable. Out on bond, probable cause was found. There's no obligation to reinstate the bond. I'm going to deny it based on the seriousness of the charges and the fact that while you're raising points, well taken, there is probable cause that meets that standard, and that gets us to revoke the bond. So the court's going to do that. Of course, not denying the motion to reinstate. Let's move this thing. Hold on a second. Where are we at? Hold on. Where are we at with the case?
So I represent him on the gun case. We have asked the state more than once to give the additional discovery that we're missing from depots. We also have to set more depots. As the officer who did the search warrant did not appear to his depot, even though he was served. And we are missing reports and evidence lists that we need, that we got from depositions. I think we're set for next month for pretrial. The trafficking case, I believe, is in front of Judge Brown, and he is represented by Mr. Niddle in that case.
Why are we not running these cases together?
I think because
Because this is a new case, Your Honor. This new case just got direct filed, I think, maybe the end of September.
Are you all intending to run them, not necessarily run them together necessarily, but
On
have
the
the same
same court
judge?
dates, on the same court dates for sure, Your Honor. Yeah, they need to track each
Well,
other.
they won't be on the same court date if they have different judges. Clerk just said Judge Brown has it, that's my point. Are we gonna, is somebody gonna move to
Yes.
transfer it? I'll transfer it, he can transfer it to me, and it doesn't matter to me. But it seems like,
And Your Honor, I'm sorry, I did forget that this was a discussion in my office. There are a few co-defendants of the new case, and yes, they're all coming to this division, I think.
okay.
So they will all be moved to this division.
Okay. Very good. I'll see you next month. Okay, you're already set December 13th.
Yes, sir. Yeah, that's all I have.
Thank you.
To the lectern, sir.
Hold on, so let me find the,
Jaden Grant.
right.
Yes, Your Honor. Travis Gates on behalf of Jaden Grant, 23 CF 1995. He's here before the court for a bond hearing.
Okay.
Yes, Your Honor. We're asking the court to consider setting a lower bond. The current bond is set at $200,000. Actually, I take that back. It's $1,005,000. Mr. Grant has asked the court if the court would consider setting a lower bond, the amount of about $25,000 cash or signature. He is 15 years old, unemployed. He does have significant ties to the area. He's lived here all his life. His parents live here. He's got significant ties as far as, I think, some other family that's living here. The allegations are that Mr. Grant and someone else went into a local vape store. The co-defendant allegedly pulled a gun and they robbed the store. Subsequently, they were picked up and have been charged with, as is grand theft and robbery with a deadly weapon, Your Honor.
This is my case, Your Honor. Again, the state would oppose the bond being reduced in this case as well. Your Honor, this is a robbery with a firearm that Mr. Grant participated in. There was two co-defendants, actually, one co-defendant used the weapon against the victim. They then took merchandise from the store, and then there was a third co-defendant who was basically the driver in this situation, Your Honor. Mr. Grant was one of the co-defendants who actually participated in the robbery. And it did look like he has one failure to appear in a prior juvenile case, Your Honor, so the state is concerned about him showing up for court as well as the offense that he's charged with.
And Your Honor, just so the record's clear, Mr. Grant and I discussed, he actually has two. We want to make sure the record's clear, two failure to appears. However, again, he is 15 years old. The co-defendant that was the alleged driver in all this got a $75,000 bond. Mr. Brooks and Mr. Grant are being held on over $1 million bond. He does have, as I said, a little criminal history that I can tell on the score sheet, consisting of resisting officer without violence, a misdemeanor, and a petty theft. That seems to be all that we've got other than two failure to appears.
Does the state have any response to the disparity in the bonds between the co-defendants in this case? Is there something about this defendant that would justify about 15 times the size of the bond?
Your Honor, I personally was not at the first appearance, so it would be an assumption that they're treated differently because one was a driver and didn't actually participate in the robbery, and two co-defendants actually participated in the robbery would be my assumption that.
What were the other co-defendants? What were their bonds?
Same as Mr. Grant's. However, it's my understanding that the driver was also charged with robbery with a deadly weapon.
As a principal to the robbery.
Well, clearly these are serious charges. I think $1 million is excessive. The court's going to order a $100,000 bond with, what are are there any other pretrial service requirements?
Not that I saw on the original bond. I was just looking at the paperwork. I take it back. It does say pretrial services.
The state wants to no bond this, and they have every right to do that. You need to file proper paperwork and actually try and get a motion to no bond it. If that's what the states really want, but $1 million is akin to a no bond.
In your
There are many of these, and it's not unusual, but The size of it is unusual.
Yes, Your Honor, just for clarification, there are 2 counts. How does the court want to break that $100,000 bond?
50 apiece.
50 apiece. And then there is pretrial services, no contact with the victim. I'll keep that the same just to address the monetary.
Absolutely.
Thank you, Your Honor.
Your Honor, I'm sorry, I didn't catch the rest of that. Are we ordering the GPS?
What I want is any requirements that are on the current bond, okay, should be on this new bond. And the defense was just listing a couple of them, no contact with the victim. Were there others? That was my intention. I'm open to any others if the state.
It says pretrial
Hold on a
services,
second.
Your Honor.
$5,000 county professional loan account too. Do you want to keep that or do you want to divide the 100?
Oh, so there were two,
Yes, sir, I've got the first appearance paperwork.
so there are 3
2 charges, Your Honor. It's
2 charges.
5,000
So-
on one and $1 million on the other.
So let's do the 5,000 on one and 100 on the other.
Yes, Your Honor.
Let's do it that way.
And
Thank
it's
you, Madam.
pretrial services requirement, Your Honor, no contact, not be within 500 feet of the victim or the victim's residence or employment.
State.
Your Honor, the state, if that wasn't stated, again, I'm trying to pull it up, I would request a GPS, but it looks like the GPS was ordered, it was level D, correct, Mr. Hughes?
It's just the pretrial services, I didn't see anything else.
Seeing that Judge Schlechter circled level D.
It's on the second page and it's circled at the bottom.
Notated, that's why I didn't want
Well, that's, I see a check next to GPS, but. Your Honor, the state's asking for the GPS monitor.
If that's the court's inclination, we'd ask it be set at the lowest cost per day.
The court will order the GPS and at the lowest possible cost.
Okay. And I'll follow up with an order later today, Your Honor.
Thank you very much.
Thank you, Your Honor.
Mr. Wilkins?
Good morning, Your Honor. Jack Wilkins for Cameron Calais. Your Honor, that's going to be case 23 CF 0808. Your Honor, present before the court is Ms. Calais. Your Honor, we were hoping to resolve this today. However, we are still waiting for some contact or some further contact from one of the officers. He was working midnights or was working nights last night. Would ask to pass this to your December 11th docket for, I believe we can resolve that or resolve this. And
So it's our next pretrial. Do you have the?
yes, sir, that would be a control date. What we're working toward, and Ms. Sharpless will correct me if I'm wrong, is trying to resolve this with a misdemeanor plea in absentia.
Sure. We'll just continue it to keep it on the books for 12/11. If it's able to be resolved through a plea, a misdemeanor plea, that certainly wouldn't require somebody, that can be done without
Thank you, sir.
a hearing.
Yes, sir.
Okay, thank you very much.
May I be excused, sir?
You may. Thank
Have a
you.
pleasant day.
You too. Ms. Jacquet? Did I pronounce that right? Close.
I hear lots of different things, but Jay quit.
Jay Quip?
Feel like-
Okay, well, I want to try and get it right.
And perfectly fine. I'm used to it. Doctor's office, I hear Smith a lot. Or just Catherine? I do not. Your Honor, I only have Michael Bryan, 22 CF 655 on the docket this morning.
Okay.
No, I'm sorry. No, I said no, I don't. I apologize. Mr. Bryan, come on up. Mr. Bryan isn't present and approaching, Your Honor. Your Honor, we were here scheduled for 2 matters. One was an order to show cause. I filed a motion to quash the order to show cause as the officer did make herself available for a deposition. So the court signed that order, so that matter is moot. However, we are also here for an order to show cause. I did note that the state filed a traverse this morning in this case. However, that is not in compliance with the rules. 3190D states that the state should file their traverse within a reasonable time prior to the hearing. And while I understand that that reasonable time could be argued about what that amount of time is, I don't think they contemplated that it would be the morning of the hearing, especially under the consideration of the fact that the notice of hearing was filed a month ago and the motion was filed 5 months ago. So I would ask the court to dismiss the traverse as untimely and grant the motion to dismiss. And if the court is not...
Do you have some case law that would give me the right to throw out the whole case based on this?
Your Honor, I have the rule of criminal procedure that states...
I got the rule. I mean, you're welcome to show it to me and to argue that, but I was just wondering if you had anything more than that, because you're asking for a pretty strong remedy. Would you
Understood.
show me the...
Yes, sir. May I approach?
You may. State's aware of this rule, right?
Yes, sir.
Okay, go ahead. What were you reading from as far as the time?
Your Honor, it is at the very last or second to last sentence of the Part D, of subsection D.
Subsection D?
Yes, sir.
Gotcha. The one that's underlined.
Yes, sir, and I apologize, I
That's all right.
underlined
No,
it for
no,
my
no.
own purposes.
I appreciate you, you pointing it out. State.
Your Honor, can we approach for just a few minutes on?
Sure.
this?
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
So we're going to continue this hearing and have the parties contact my judicial assistant to set this for a longer hearing in the afternoon on a miscellaneous date.
And Your Honor, just for the record, is the court making a ruling that it is going to allow the stage traverse despite the untimeliness?
Correct. But you had said you had other arguments, so I was just going to kind of bundle it all up and I mean, if you want, I'll allow you to come back on the later date, because I asked you for some case law. If you had case law that was a clear, you're late, you're out.
Well, if I had gotten a traverse before
I understand that, that's
this
why
morning.
that's why I'm allowing you, so I'm not gonna make a ruling
Okay.
on that. You haven't had time to really address this. We'll come
Yes,
back,
sir.
you can address that, you
Perfect.
can address the other issues that you want to raise, and
Perfect.
let's litigate this on the substance, or its procedural substance.
Yes, sir.
Rather than just try and push it through quickly.
Okay, and that was
So
why I wanted to
the court's
verify.
not making any ruling
Gotcha.
today, just continuing it
To give me
for a
time to,
date, TBD, to
Gotcha.
get it rescheduled. And again,
Perfect.
ask Miss Eileen for maybe a half hour. That'll be.
yes, sir, perfect.
Thank
Would
you.
the court provide, does the court require the counsel to provide a memorandum of law prior to the hearing?
It would always be helpful.
Yes, sir. Perfect.
Those are very helpful to do that.
Yes, sir.
Okay.
Thank you very much, I appreciate
Thank
it. That's all I have before the court. May I be excused?
You may.
Thank
Thank you
you.
very much. Okay. Mr. Patel, you're not, I don't have any of yours. You're not on the list yet, so, but you're here, so come on up.
Thank you, Judge. Several before the court. The first one, Jay Patel, on behalf of William Friedsberg. He's present and approaching. Mr. Friedsberg. What's that? No.
No, yeah, both of them are non.
Judge, Mr. Friedsberg is before the court for a change of plea. He's presently charged with 23 CF 523, 2 counts felony, grand theft, and uttering a forged instrument. This is a plea, so he's entering a plea of no contest, but it is with a PTI. So the agreement is a 12-month PTI agreement with deferred sentencing. The understanding, count 1 and count 2, the defendant enters a plea of no contest with the understanding that the plea is to a 12-month pretrial intervention plea that shall be set aside upon successful completion of the terms. The terms are as follows: complete an anti-theft course, remit $4,000 in restitution to Billy Teams. My client has already given me those funds, so I've stated on the plea agreement, and I'll state in open court now, that based upon how much it is, I would like Mr. Teams to personally come to my office to retrieve the cashier's check so I can get a receipt and then put that and then file that with the clerk.
Okay.
State has no objection to that. I have the PTI agreement and I have the written plea agreement. May I approach?
You may. Thank you. State in agreement.
That's correct, Judge.
Okay. Mr. Friedsberg, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. It's a little bit of a unique plea agreement because it has, from your point of view, a very beneficial and a kind of a very not beneficial outcomes. The beneficial is that if you follow through and complete the PTI, you get your charges dismissed. That's obviously a big plus for you. But if you don't, we'll go right to sentencing. In other words, you've pled no contest to this, you can't come back and contest it and go to a trial. Do you understand that? So in that degree, this is a final resolution of this case. Obviously, you have to complete the PTI. But you understand that this will be a final resolution of your case, and you're waiving the right to go to a trial and a hearing, some valuable legal rights that you have as a defendant. Do you understand that?
Yes, Your Honor.
You've gone over all that with your attorney, made sure you had all your legal questions answered?
Yes, Your Honor.
You believe this is in your best interest to do this?
Yes, Your Honor.
Very good. Based upon that testimony, the court will accept your plea in the no contest on counts 1 and 2, and the PTI agreement with a deferred sentencing if that is necessary, and a dismissal. There also includes restitution as stated by your attorney that are contained in the plea agreement that the court notes the defense has signed. You went over this plea agreement with your attorney?
Yes, Your Honor.
Any question?
No, Your Honor.
Thank you. Okay, thank you. Would you hand this to probation?
Yes.
Yeah, that's right. Yes, sir. Thank you. Thank you, Madam Clerk.
Next, Judge, Jay Patel on behalf of Jason Kremges, 23 CF 1274. Judge, we have a resolution. We haven't gotten all the PTI paperwork completed in that. I'd like to set that for 12/11, and then we intend to submit the paperwork to you before then. It'll drop off.
Very good.
And then finally, Judge, I have a case that's set for 12/11, which I have a written plea agreement for a misdemeanor. Can we handle that today?
Sure.
Jay Patel on behalf of Eric Michael Kraft, 23 CF 10.
Who's the state attorney? I just want to make sure so you're aware of this?
That's correct.
Okay.
Jay Patel on behalf of Eric Michael Kraft, 23 CF 1011. We have a written plea agreement for a misdemeanor. May I approach?
You may. And the state's in agreement?
That's correct.
Okay.
And Judge, to note that will be supervised by county probation. It's written on the description.
Okay. Very good. Anything else on this? Thank you.
Nothing further may be excused.
Thank you. Have a great day. Okay. Any other private attorneys here? No? Okay. Mr. Harper?
Judge, mine are both in custody. I don't know if you want to clear up a little bit more.
Can't.
I can pull his, we have his up and ready. We've got a lot of them. Okay.
Yeah, let's go ahead and go. We'll just go down through the order.
11 through 13.
Before we do that, why don't we go ahead? We've got 3 without attorneys, and they all appear to be out of custody. Is Travis Cruz here? Okay. Juvenile, TJ, children.
Oh, gotcha. Ma'am?
Okay.
That's mine.
Would the state announce for Mr. Cruz, Travis Cruz, case number 2020 CF 842?
Yes, Your Honor, this is, as the court said, 20 CF 842. Mr. Cruz is here for a violation. Your Honor, in regards to Mr. Cruz's case, I was notified by Officer Morales that the conditions that caused his probation to be violated have since been resolved with probation. At this time, the state is recommending adjudication, credit for time served, revoke and terminate probation, and send what's remaining to a civil lien after 1 year if Mr. Cruz is prepared to accept that.
Yes, sir, you are.
And what is the amount of the outstanding civil lien? Do we have that?
Just a second, Your Honor, I apologize.
She refused to come.
I figured. We can address her.
We can address her.
Do we need to paper this too?
We certainly can, if the court prefers that, I will do that.
Clerk, I do.
Your Honor, the report.
Okay, why don't we go ahead and paper, you just put it on thing, hold on for a little while,
Yes,
let's
sir.
get it written and
Yes, sir.
we'll go from
All
there.
right.
Okay,
Thank you.
Mr. Patel?
Yes, Judge. Probation notified me of a potential issue with Mr. Freedsburg case.
Okay.
We just need to set a recall date or a control date.
Yep.
Want to do
How
like January?
You want to do it, usually we do it at about 6 months? January, good?
January is fine. We probably won't need that.
Okay, very good. Let's do it in January.
It's for a background check.
So today's plea is going to be put off until another time?
No, it's a recall on the PTI. In other words, a kind of a status report.
No, different than that, Judge. They want to do a control date to make sure that his background is clear for a PTI, which we know it is because he didn't have any criminal history, but
Okay.
they just want to make sure. So if we can just...
So
should we-
what time, do we need to just do some type of a status?
If we can just do a status on the January pretrial, I know I'll be there, and then likely it'll just fall off.
Very good. We have the date now.
It should be underneath, 2024.
Okay, so that would be, January 16th is out of custody. We'll do a status for the
Perfect.
background.
Thank you, Judge.
Thank you. Okay, a couple other without attorneys. Well, actually, yeah, just two. Mr. Leroy Figures. Leroy Figures State.
One moment, Judge.
Your Honor,
Yes,
this is for Mr. Leroy Figures, case number 23CF1120. He does not appear to be in the courtroom at this moment.
I think is there another case also? I've got two cases for him.
Yes, Your Honor. It should be 23CF1120 and 23CF1390. As court security stated, there is a warrant already out for his arrest.
Okay. So, do we need to do another warrant if one's already out?
Is the warrant?
The other one clears, this one would still.
I think it's failed to report a new...
We have a probation violation, criminal summons on a PC for retail theft, and another criminal summons.
So I don't think, probably enough? Okay, so I don't think we need another one. Okay, so, just for this, do you want to wait till he's served to set another date? Do we need to set any kind of a date out there?
No, Your Honor, I think it falls off the docket at this point.
Okay.
And
Wait for him to be picked up.
Madam Clerk may have a clarification for us, so I'm looking.
Well, the VOP was served on 10/6.
And I think there was an amended violation after that.
That pickup order was done on 10/31, so it's the pickup order that's outstanding, Your Honor. That's what it is. So the VOP was served. Do you want an FTA on the, because he was ordered to appear with the arrest paperwork.
Yes, there is a failure to appear on this, on the violation of probation. My question is, do we need to do a warrant? And we've already got one, Capias. Yes. Okay. Cherie Sorrells, is that Sorrells? I don't know if I pronounced that right, but would the state announce on this?
Yes, Your Honor.
Come forward to the podium, ma'am. Thank you.
If you'll give me just a second. This is 22 CF 3035, Your Honor, and if I'm not mistaken, this violation is based on a new law charge that I believe is with Mr. Gates.
It is, Your Honor.
If Mr. Gates could be appointed to this case also, Your Honor.
Ma'am, you do have a right on this violation of probation. You had a new law charge that created a violation. If they're actually separate, I have to ask you, do you want an attorney?
Yes, sir.
Yes, so the court will appoint the public defender, and you want to just run them together with the?
Yes, Your Honor. I
other
think
case?
Ms. Searle's other case is scheduled for, if I'm correct, December the 11th.
Okay, so we'll continue this until September 11th, okay? Stay in touch with your attorney in the interim, okay? Okay, thank you. Okay, Mr. Harper, I'm sorry to.
DeVoris Berry, Mr. Berry. He's not yours. Oh, sorry, Mr. Berry. I have this RC. Is Barry yours? Medina?
I guess I just.
Steve will let you know if it was his.
Judge, it looks like I was recently appointed to divorce Barry's case. Can I bring him back next Monday?
Sure.
That way I'll speak with Mr. Barry and see how he'd like to proceed on this BOP.
Yes, sir.
Okay.
On
You're looking for the next miscellaneous,
the
right?
21st, yes, next miscellaneous.
So that's next Tuesday.
Sorry, Judge, yes.
How many do we have on that? Austin? You can look for all of them. Not really. Okay, so we'll be careful not just to. Thank you.
Judge, on Mr. Costin's case, we had set this for a possibility of a,
Did you announce the case numbers?
this is 23 CF 1401 and 23 CF 1402. Need just a moment, Judge. Judge, if we can set this for December the 11th, actually December 13th, since he's in custody. Mr. Costin's advised that he might be wanting to plead straight up to the court. I just need to speak with him about that and how he wants to proceed.
Very good. We'll continue this till December 13th at 9 a.m. Okay. Stephen James.
Judge, this is Mr. James, 21 CF 1159 and 21 CF 1666. He's before the court on a violation of probation. Your Honor, I spoke with the state. I addressed an issue with respect to the score sheet. I think it's possible we can come to a resolution relatively quickly. If I can bring him back on Tuesday, I think the state and I can come to an agreement.
That's correct, Judge.
Okay. We'll come back on 11/21 and 9.
Thank you, Judge. That's all I have today.
Very good. Thank you, Mr. Harper. Mr. Gates?
Yes, Your Honor, I will make the out of custody that I have.
Okay.
I'm sure please put eyes on people. Your Honor, if I can call Donald Frazier.
Okay.
Mr. Frazier, before the court in 21 CF 1956.
He's doing the out of custody.
Yes, sir.
Your Honor, this is Mr. Frazier. The statement I talked about, we're waiting for him to get his certificate from the substance abuse class. Once we do that, my anticipation is that we'll be admitting for time served, terminate probation. If we could continue him to the VOP cycle in December.
Okay. That would be December 14th, 9 a.m.
Thank you, Your Honor.
Okay. Madam Clerk,
Make sure I write the correct date first. Make sure to get that approved to me and to probation, okay? December 14th, okay? Call my office to make sure I get all that, okay? Call my office, keep me updated, all right, Donald? All right, okay. You're welcome. Your Honor, next I've got is going to be Teresa Gore.
Okay.
You know, this is Ms. Gore before the court. The state and I have talked about a resolution in her case. Ms. Gore's got some stuff she needs to get resolved before we can enter a plea. If we could continue without subpoenas.
So you want to continue until the December
Docket, Your Honor.
December 14th, 9 a.m. Okay.
Get that done. Your Honor, next I've got is going to be Parker Gurria. I saw that he was here and wanted to make sure the state and I discussed the plea agreement. You good with what we talked about? Extend auto or determination upon completion and all that?
Right, yeah, as soon as I'm done with this, I'll just be streaming. Okay, I'll see, I did my third class, so I have, I have 5 more classes, 5 weeks.
You good with what that one? Extend it, I think 6 months.
I will
Terminate.
Okay, just like extend it to include everything.
Yeah.
Okay, yeah, sure.
Your Honor, if we can pass Mr. Guria, we've got a plea agreement worked. I just need to write it up for the court.
Pass them today?
Yes, Your Honor.
All right, it's all right. I'll stay here.
Stay here for a second, okay? Your Honor, next I've got is going to be Dayton Bragg. Mr. Bragg is coming up, Your Honor. It's another one I may pass. I just need to clarify some information with him real quick.
So we're going to pass on this one as well?
Let me clarify.
Okay,
Your
go
Honor.
ahead.
Your Honor, the state and I have talked about doing an inpatient program for Mr. Bragg. He's asked to be screened for Phoenix House. Any objection to continuing and let us get that screening done?
No objection.
If we continue Mr. Bragg's case, I'll start the process of that.
Would a month be sufficient?
As long as we can stay in touch with Mr. Bragg, we should be able to get that done by then.
Okay, we'll continue it to, let's do this one on the 19th of December.
Thank you, Your Honor.
Okay, stay in touch with him, okay? Mr. Gregg, stay in touch with your attorney.
And Your Honor, that's all that I have that I could see that are present right now. If I could step away and talk with a few others, Your Honor.
Mr. Medini, you want to do a few?
Yes, Your Honor, I have 2 out of custody that I can call. First would be Sebastian Orr with a VOP agreement, Your Honor.
Okay.
Mr. Sebastian Orr is approaching. He's docket number 50, 22 CF 2283. We have a signed violation of probation agreement. I'm going to make a photocopy so I can advise what's in it, Your Honor, if I may.
Okay.
I did add one slight addition. I need to show you one thing. I can approach with the agreement. Your Honor, it's a VOP with a reinstatement, so I do not think we need a score sheet.
Very good, thank you.
Thank you.
Would you announce the plea?
Yes, Your Honor. The provision that I added, I don't think Ms. Sharpless is going to have a problem with, but so I'll go ahead and announce.
Okay.
If I can get my phone to work, Judge, I need a 12-year-old to show me how to work this thing. So all of a sudden. Okay. I'm sorry, I'm going to have to take my glasses off, Judge. I can't enlarge it. Your Honor, under the terms of this violation of probation agreement, it does reflect that Mr. Orr was previously adjudicated guilty of a third-degree felony. It would be a reinstate and modify to include community control for a period of 1 year. He would have to get a substance abuse evaluation within 30 days and commence any recommended treatment within 60 days. That's what SAET means. You understand that? And he has to complete original requirements. There's $100 VOP fee, $150 public defender fees, and the provision I added, I need to make sure he's already doing community control that was pled out on October 17th.
What he's doing in San Diego.
It would be concurrent. Okay.
That's fine.
So-
That's fine, Your Honor.
So I had added the language, may serve concurrent with Santa Rosa case.
Okay, so the Santa Rosa case is also community control?
Yes, Your Honor. It's my understanding he took community control October 17 or thereabouts in Santa Rosa County. Was that also for 12 months?
Yes, sir. Okay.
And then, meanwhile, once community control is over with, will be some remaining probation. I'm not exactly sure what the termination date, but the violation report indicated a February 19, 2025 termination date, Your Honor.
Okay, I'm sorry, you just confused me.
After he finishes the 12-month CC, there will be some remaining probation. So this does not get rid of the fact that there would be.
That would fall under the category of the original requirement.
That's correct, Your Honor.
Okay.
So it's being
Do you
modified.
have any idea how long, I mean, I'm not holding you to it, but just in general, so want to make sure that the defendant understands this?
The scheduled termination date said February 19, 2025. So unless that has
It's
been...
almost a full year in addition.
That's correct, Your Honor.
Okay. Would you raise your right hand, sir? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, I do.
Okay. So just want to make sure you understand what you're entering into and you're doing it freely and voluntarily.
I don't fully understand that part.
Okay, well, I'll go over it and let's talk about it, okay? So what's contained in this written agreement that I see you've signed, you've read through this, right? Gone over it with your attorney?
Yeah. Yes,
Okay,
sir.
but I understand some of this stuff is tricky, and that's why I want to make sure and clarify it. So we're going to reinstate and modify. You're going to have a community control for a period of 1 year. That'll run at the same time, concurrent with your Santa Rosa. But you already have some probation that's for almost 2 years worth of probation. You understand that? From on this case. Not the community control, just regular probation. You've got it. It's not supposed to end until approximately 2 years, October of 25. That's 2 years from now.
Your Honor, I apologize, but it is a scheduled termination date of February 2025. So that's,
Okay.
he's
So
already
that's
been supervised since February of this year. So it's not
Okay, so-
October, it's
Okay,
February.
so it's not a year. So the bottom line is, you've got approximately a year of community control and then a few more months of regular probation. Because you've got to finish your original probation, which is really the same case. Okay, you following me?
Yeah, I understand that.
Okay. So in addition, you've got to do, importantly, the substance abuse and follow through. You're going to have to get on that quickly. If not, you won't be able to finish, and they'll try and be violating you and all that on this. You understand that?
You quickly, how fast quickly?
Well, this says you have to try and do the evaluation within 30 days and start within 60. That would be, you don't want to, certainly you can't be more than that. So this would be quickly, 30 days to do the evaluation, 60 to start. Because whatever they tell you, it's going to take some time to go through the program. If you come to the end of this thing in about a year and you haven't finished it, they're going to try and violate you, or they could. Okay. If you're going to work, if you work it, they'll work with you, and we will too. We want you to deal with the substance abuse. I'm just telling you straight up. That's the root cause of all this.
And Your Honor, may I address the court on that? It's always possible, just so he's clear, is that you get the evaluation within 30 days. Depending on the results, you may or may not have to do recommended treatment. It will be up to the
They say
evaluator.
you're good. You don't have an issue. That's the thing. You got to do an assessment and then follow whatever. But you can't. The problem is, with all due respect, a lot of people just sit on this stuff. And they don't do it for 6 months, and then all of a sudden they're coming to the end of their probation. They can't finish.
Yeah, I got the Bridgeway paper. I just got to find some time to go up there and do it.
Okay. Well, this needs to be a priority. I mean, that's the only way I'm going to say it straight up. Try and be honest with you. We want you to be successful, and you got to get on it in order to do that. Okay? So, you've had a chance to read this. Had all your legal questions answered by your attorney about this plea agreement?
Yes, sir.
You understand that by entering into this, you're waiving the right to go to a trial and contest all this?
Yes, sir.
Okay. And you know about community control because you're already on community control and you understand that.
Yes, sir.
Do you have any questions concerning what this plea agreement is?
No, sir.
And Your Honor, he'll report to 13 Kelly Avenue, Fort Walton Beach immediately
Today.
as he leaves the courtroom.
Okay? Is that okay?
Yes, sir, it is.
So you talk to that gentleman.
Do you have any questions?
Nah, no, sir.
Thank you, Your Honor.
Thank you.
Your Honor, next, okay, thank you, good luck. Next is Leah Perillas, Your Honor. Ms. Perillas is in the courtroom, docket number 51, and she is 21 CF 1074. Your Honor, we're going to need to continue this case. She had a PO recommendation of a modification for drug offender probation. The state has indicated that the state attorney's office position is Keaton or Phoenix House, so I'm going to have to discuss that with her and potentially get her evaluated by those facilities to
Is
see if
December 14th all right?
Yes, Your Honor, that should be plenty of time.
We'll continue this till December 14th at 9 a.m. Stay in good communication.
Yes, sir.
With Mr. Medina in the interim, so you can kind of figure this out, okay?
No problem.
Okay.
Thank you.
Yes,
Great day.
yeah, get in touch with us right away so we can work on an evaluation if that's what you're going to do.
Will do.
Thank you, ma'am. Those are my out of custody, Your Honor.
Okay,
Thank you.
very good. You want to, so Mr. Gates is not here, so you want to, you want to go ahead and start with your
I can do,
you want to take a break?
it may be efficient
We'll
to
take a break, and then we'll come back and start doing the in custody.
Thank you, Your Honor.
Okay?
All rise, please.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Ferdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Pretch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
I'm gonna call one. Right here.
And the flame? Yeah.
Which one do you want to do first, Mr. Gates?
Your Honor, if I can call number 13, Gabrielle Flanagan.
Okay.
Ms. Flanagan's scheduled for a bond hearing this morning.
Correct.
She refused transport, and based upon the conversation I had with her, my understanding is that she wanted to move forward on the bond hearing with her parents representing her, is what she told me, but based
Can't
upon
do that.
And that's what I tried to explain, Your Honor, so.
Denied.
Yes, Your Honor.
Don't show up, you gotta be here.
Yes, Your Honor.
Your Honor, the victim is present in this case. Because it's a violent crime, Marcy's law is in effect, and I believe he wants to address the court. His name is James Flanagan. He is the defendant's father.
Okay.
And I'll step aside and let Mr. Flanagan
Why don't you
come.
come up to the witness stand?
Yes, sir.
Please raise your right hand. Madam Clerk, would you swear that?
Ask him what he wants the court to know.
I did. Thank you, Your
So
Honor.
would you identify yourself and?
My name is James Flanagan.
Okay.
My daughter is.
Go ahead and sit down. Go ahead and sit down. You want to inquire of him, or you want to just?
No, Your Honor, I don't have any questions of him. He just wanted to address the court, and I wanted to let you know he was present.
Mr. Flanagan, you may address the court.
My daughter is sick. She was in bad need of mental health treatment. We have been seen by Dr. McDonald, I understand is an expert in the court. She's also seen by Pearl Oaks mental health professionals. And I have a letter here from them that states such. She's been in lockdown for 60 days. She's getting worse and worse every day that goes by. We're losing contact with her. It's a little bit, as you can tell, a little emotional thing. I'm trying to put the best I can. She's been diagnosed with stimulative psychosis. She is now, after 60 days, not doing that anymore, obviously. She's not getting any drugs, but she's been locked down for every hour, or all but 1 hour every day, ever since, as far as what we can tell, at the jail. Jail is not treating her for anything. They told us that they were going to move her to the medical facility, and they haven't. They haven't done anything to help our daughter. She's getting worse and worse all the time. She needs to be diagnosed properly. We understand that the expert witness has suggested that she go to the state hospital, and that is devastating for our family. It's the worst thing you could possibly think of. Any person that you love going to a state hospital where there's a variety of different mental health problems there, you know, with lots, much more serious.
Mr. Flanagan, I'm going to interrupt you just a little bit. I mean, the primary purpose of Marcy's Law is not to allow victims to advocate for the defendant. But I want to say to you, we all understand many of the challenges dealing with mental health in the criminal justice system, and it is not a good system. It's not good. So I understand, but hold on. You've been aware of this. Is there anything, where are we at as far as any type of mental health evaluation?
I am waiting for the report from Dr. McDonald, Your Honor. That's the sole reason this wasn't noticed completely different than a bond hearing, is I don't have that report yet. Until then, I have to follow her request, which was to have the bond hearing.
Okay. And what do you, not getting out in front of ourselves, I mean, that's a competency hearing.
Yes,
so
sure.
what are we, what is the defense trying to, where are we trying to go with this?
I think Mr. Flanagan has kind of touched on what we expect the eval to come back as.
And what would that result in? Would that result in a state hospital?
Yes, sir.
I would agree with the defense's characterization of events. I do think that this is a bit of a premature conversation to be having since we don't have the report back yet.
Well, no question. And we're not, the court's not taking any action because it's not being asked to. So, but I appreciate that. But the fact of the matter is, there are issues, and if we can address them, we can, but a lot of times we can't. And again, I'm sympathetic, but my hands are tied just like a lot of the folks at the jail.
Can I say one more thing?
Sure.
I didn't previously, leading up to this, provide the leadership necessary for my daughter to not be in this position. That's
Sir, don't take the blame for this. This is not about you. She's got an issue, and unfortunately, what is happening in our society is that oftentimes drugs are dramatically exacerbating mental health issues, and you know, we have limited ways that we can approach this, and we will continue to do so. I will tell you that the defense counsel will move on it as quickly as can. He's a very conscientious and capable defense attorney, but his hands are tied until we get the report back.
Accepted into another hospital, Your Honor?
The folks right here has accepted her, and if we could get a bond, then we could have her immediately taken over to a program where she can begin treatment and help and diagnosis. This file is full of us researching over and over, trying to figure out what's wrong with our beautiful daughter, and it's heartbreaking because she's just rotting in jail, and we can't get the state to agree to a bond so I can take her to the hospital. And that's all I wanted. That's all I wanted when she was arrested, although she didn't, you know, we didn't know she had been violated. The bond had been violated at the time. All I wanted was her to go to the hospital. And ended up, the bond was violated, she goes to jail.
So if she's okay, you can step down. If she can be in a mental health facility, is the defense aware of that?
I've I've had this conversation with the victim
You
several
can go ahead,
times.
sir.
And what I've said is if the defense was only against him, certainly I would be standing up here. I would stipulate to a bond weeks ago, probably a month ago, Judge. But the problem is every time she is released, she bothers her dad and then she turns around and fights law enforcement while she's being arrested. And it's happened twice in a row. So because of that, I can't stipulate to a bond here and put law enforcement in harm's way again. I just can't do it, Judge. So that's my position.
So we have a person who's mentally ill and violent, and we can't let her out of jail because you're afraid that the police officers can't handle themselves dealing with a mentally ill, violent person. Is that what you're saying? That's what I'm hearing you say. I mean, I'm just asking if we can get if we can be confirmed that we can get a transfer to a mental health facility.
I would be fine with that, Judge. If she could be transferred directly from the jail to the mental health facility and remain there, I would be completely fine with that.
I don't know what the mental health facility is, but
I'd ask the state to make sure, but he's got a copy of it here, Your Honor. If I can approach the same copy that the state has in its possession. It looks like they've gone through the process of having her screened and approved for the 12 Oaks program, which does address in the letter some of the mental health concerns that they've expressed to the court.
how can we get her from the jail to this facility?
I think what we could do is, if the state, depends on the state's objection, but have her release the signature to her parents with the understanding that she goes straight to the program and remain there until she completes the treatment
How will
therapy.
she literally physically get from the jail to that program?
The parents, Your Honor, who have strongly advocated since day one to get her into a treatment program.
And the state's okay if we make it a condition of the bond that she enter into the program?
Yes, Your Honor, as provided that she remain in that program, I would be fine with that.
Well,
my concern here is also for law enforcement officers, if this goes south, that they would have to get involved again. However,
Aren't you concerned with law enforcement officers in the jail? Aren't the jail officials having to deal with her every day? Can't they get on the receiving end of violence? I mean, I understand we have police officers, but our police officers are trained when we have individuals that are violent based on clearly mental health issues that everybody acknowledges. I'm not trying to put our law enforcement in harm's way, but aren't our jail officials in harm's way?
certainly, Judge, I believe it's a controlled environment. What I was attempting to do was not repeat what already happened once before, where we release her from jail into the custody of her parents, then she bothers her parents, and law enforcement is called all over again.
And
we're gonna have to take a chance.
I was going to say that the court likes to quote the one definition of insanity, and I think that specifically addresses some of the mental health issues we've got here.
Yeah. Okay. We need to have the order. I'm going to allow you all to work on the order to make sure that it's the state's satisfaction, that, it's directly to the program. And,
yes, sir.
And we're going to say that it'll be in the custody of her parents to get her there.
Yes, sir.
And, we are taking a chance. And you're taking a chance, and, it's,
and if,
particularly, she gets out and she may not want to go.
She's agreed already.
Well, yeah, okay. Well, today, that's the definition of if you got mental health issues, that it might change when she's out of jail. Generally, people will say anything and do anything to get out of jail. But when they get out, they don't always do it. But I'm willing to take a chance, and certainly, the only thing I would say is if there is a situation where I'm just asking you to do this, I'm not ordering you, this is not an official, I'm saying common sense, that if there is a situation during the transport that you have to, call law enforcement, you got to let them know that there's mental health. There's this, this has been before the court, and there's mental health issues, and she's had some issues with it. You just need to try and talk with them. But we're making it as a condition of this that she attend and stay in 12 Oaks. So that means that if she leaves 12 Oaks, she goes back to jail. That's a condition of the bond at this point. Hopefully, and this is I don't know how long of a program is the 12 Oaks. It's usually a 60 or 90, right? Which honestly may not be long enough.
I think it's just.
But at least that's a start.
And there was some confusion with her parents last time. Essentially, I want to make sure that the parents understand that this is a court order and she has to comply with this condition, because there were some issues about the earlier conditions of bond that she may not have been complying with, that the parents understand she has to do.
And what's going to happen if she doesn't comply with them? She'll be in violation of the pretrial services, and she'll be put back in jail.
Yes, Your Honor.
And I will speak with the state about a monetary with a signature bond, pretrial services, the 12 Oaks requirement, stay until completion of the program.
That's correct.
Okay, and if you will approve the form of the order to make sure that the protections that, whatever we can have, try and have in that order. If you have any issues, let me know and I'll make a call on it.
Won't have any more issues, I'm sure.
Well, don't make a promise you can't fulfill. We're going to do the best we can. That's all we can do.
Yes,
so sometimes the best we can. And appreciate your advocacy, in trying to do this. A lot of people don't have the benefit of that. So, okay, thank you.
This is going to be Jeremy Gafford next on the docket. The state and I talked about Mr. Gafford's case. If we could continue his VOPs without subpoenas, I'm trying to work on some sentencing alternatives for the state to consider.
Are we going to do it to the next miscellaneous 12-14?
Yes, Your Honor. Either 12-14 or 12-19, whatever the court's inclined to do.
We'll do it for 12-14.
Thank you, Your Honor. And that's at 9 a.m.
It's at 9 a.m. in the morning, absolutely.
Yeah. This should be Mr. John Goodman with the eventually get it right. We do have a plea agreement to be filed from Mr. Godwin, Your Honor.
Very good.
Get the score sheet for the court. Your Honor, this is going to be a DOC sentence. And not a downward departure, but the state is stipulating to previous DOC credit. If I may approach.
You may.
You already signed it. Score sheet. And no objection to the score sheet.
Thank you.
Thank you.
Would you please announce the plea, counsel?
Yes, Your Honor. Mr. Godwin will be admitting the violation before the court. He will be adjudicated guilty. We're going to revoke and terminate his outstanding probation. Sentenced to 21.825 months Department of Corrections with credit for all time served. State will stipulate to the defendant having served more than the 21.825 months DOC when be eligible for immediate release. $100 cost of prosecution, $150 defender fee. Mr. Godwin's asked for 24 months from today to pay those outstanding fees.
And the state is in agreement?
That's correct, Judge.
Mr. Godwin, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms. Obviously, good deal for you. You got credit for time served already, what's being sentenced, but this does have some legal ramifications. The adjudication of guilt and the DOC sentence can be on your record, et cetera.
Yes,
I want to
sir.
make sure you've gone over,
Yes,
had all
sir.
your legal questions answered by your attorney, and you're satisfied that this is in your best interest.
Yes, sir.
You understand this will be a final resolution of your violation of probation.
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt, revoke and terminate probation, and you'll be sentenced to 21.825 months in the Department of Corrections with credit for all time served, with the state stipulating that the defendant has already served that 21.825 months DOC and that you'll be eligible for immediate release. There are costs, prosecution, public defender fee. You'll have 24 months from the date of release to pay. If not, it'll go to collections.
Yes, sir.
Okay, questions?
No, sir.
Okay. Thank you.
Thank you, Your Honor. State.
Mr. Galvin, over here.
Your Honor, next is going to be Paul Gunnels, be number 22 on the docket. We have a plea agreement to be filed in Mr. Gunnels' case. It is going to be a modification, so a score sheet will not be necessary.
Okay, thank you. Would you please announce the plea agreement?
Yes, Your Honor. Mr. Gunnels is going to be admitting the violation before the court. He's going to previously adjudicated guilty. We're going to modify and reinstate his supervision. The next 12 months will be on community control, followed by the balance of supervision, which was regular probation, $100 cost of prosecution, $150 public defender fee.
Complete original requirements.
Complete original requirements, yes, Your Honor.
State in agreement.
That's correct, Judge.
Sir, Mr. Gunnels, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are in the written plea agreement that you've signed. So have you read this closely?
Yes, sir.
You gone over it with your attorney, make sure you understand all the legal ins and outs of this plea agreement?
I have, sir.
Because it does affect you legally. You're waiving the right to go to a trial, etc. You understand that?
Yes, sir, I do.
And importantly, you're being kind of upgraded to community control for the next 12 months, and then the rest of it will be on regular probation. And I'm going to say something to you. I'm not trying to threaten you, but I'm just talking to you facts. You understand how this goes. Usually first time you get probation, then you get regular, you get, probation. Then it bumps up to community control. If you mess up there, what happens?
Probably DOC, sir.
Right. And that's what I don't want to happen. So what I'm telling you, get up every morning, do what you need to do. This is house arrest. It's not easy to do. Your probation officer has to be your new best friend. And I mean that just to stay in touch with them. Okay, they'll work with you, but you got to do your part. Get through this thing so you don't end up back in jail, okay?
Yes, sir.
Any questions?
No, sir.
Okay, very good. Based upon testimony, the court will accept your plea. There'll be an adjudication of guilt, modify and reinstate probation, sentence you to 12 months of community control, followed by the remainder of your original probationary sentence to be on regular probation. Fees and costs, you do have to complete all the original requirements. Okay? Any questions?
No, sir.
Good luck.
Thank you.
Your Honor, this is going to be Brandon Kendrick before the court. He's number 25 on the docket. He also appears on the afternoon docket. I want to give the court the right number here, as number 35 on the PM docket as well.
Okay.
After speaking with the state, we are going to enter a denial and a not guilty plea. It sounds like Mr. Kendrick's going to be entering drug court tomorrow.
Okay. So for this afternoon's, are we entering a not guilty plea on that?
Yes, Your Honor. And if we can, and we'll just for record-keeping purposes, move both cases to the 13th, but my expectation is that he'll be released to drug court this week.
Okay. Will you anticipate in December him still being incarcerated?
No, Your Honor. My expectation is tomorrow afternoon he'll be sentenced into drug court, and these cases will be resolved. The December date is kind of a control date for Madam Clerk.
Why don't we do 12/11?
Yes, Your Honor. My expectation is it'll fall off the docket well before then anyway.
Okay.
Your copy, all right?
Thank you.
Thank you, Rob.
Thank you. Killingsworth?
Your Honor, this is Mr. Killingsworth. He's on today's docket this morning as number 26. And like Mr. Kendrick, he's also on the afternoon docket. And just to make sure, number 37 on the afternoon docket. He's noticed this morning for a bond hearing. After speaking with the state, we would ask the court to continue the bond hearing to next week, the 21st. We are expecting some video surveillance to come in. Once we review that, I think we'll all be in a better position to argue for a bond reduction.
Okay. So what are we doing on this afternoon? Entering a not guilty?
Yes, Your Honor, if we can enter not guilty on that as well.
Enter not guilty, and we'll come back on 12. We'll do it for 12:13. We'll move it if we need to.
Yes, Your Honor.
Based on the bond hearing.
And if we can go ahead and have the bond hearing scheduled for next Tuesday at 9 a.m., Your Honor.
Okay. Okay, we'll do it. We're running out of slots on that night.
Yes, Your Honor. I think this was the only one I was going to ask for that court date.
Okay. Thank you. So we'll come back on November 21st then on this one. Continue to November 21.
Thank you, guys. Thank you.
Scrivani. Scrivani.
What's that?
Should be Scrivani and Taylor in there.
Yes.
It's not. Kevin, this is going to be Miss Andrea Taylor before the court. If we can continue her case to the December 14th, 9 a.m. docket, the state and I are working on some additional discovery.
Okay, which one is this now? I'm sorry, Andrea Taylor?
Yes, Your Honor, Andrea Taylor.
And continue till when?
The December 14th docket, Your Honor.
Very good. We'll continue to December 12th, excuse me, December 14th at 9 a.m.
This is Ms. Scrivani, Your Honor. The court will allow me to see if I have a copy of an updated score sheet for the court. You good? Get that last page. There we go. Your Honor, we do have a plea agreement to be entered in Ms. Scrivani's case. It is going to be a plea to the court. There is a cap of the guideline sentence. We have no objection to the score sheet as scored, if I may approach, Your Honor.
You may. Thank you. And the state's in agreement?
That's correct, Judge.
In the 57.15 months, that's the, I didn't look at it, I should have looked at it, that's the...
It's the minimum guidelines as well as the cap, Your Honor, on the plea to the court.
Very different. Ms. Scrivani, if I pronounced that correctly, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
Okay. Speaking to that mic for me, slide over just a little.
Yes.
So, you heard your attorney state the terms of your plea agreement, and I see that you've signed the written plea agreement that contains those same terms. Have you read this plea agreement closely?
Yes.
Gone over it in detail with your attorney?
Yes.
Importantly, you're waiving some valuable legal rights because even though you're pleading to the bench, in other words, the sentencing portion of it is going to be put out, and you're going to be able to argue about that. Your attorney is going to be able to. But the, you know, the, you are pleading to the court at this time, so you won't be able to, if you don't like what I sentence you to on that day, if I do sentence you to something, you can't say, well, I didn't want to do that. Okay? So this basically is a final resolution of your case, except for the sentencing. Okay, do you understand that?
Yes.
So by doing that, you're waiving the right to go to a full trial, force the state to prove their case. You're waiving that right. Do you understand that?
Yes.
You hesitated just a little bit. Is there something you're not, if you have a question,
Your Honor,
this is the time to do it. If you're nervous and you did, but I just want to make sure you understand what you're doing. That's my whole purpose of my questioning.
And just to clarify, the court did say trial. It would be an evidentiary hearing, which would be a judge trial, which is what I explained to. I think that may be the slight hesitation.
Your attorney is more precise than I am on this statement, and he's correct. It's an evidentiary hearing. It would be a bench trial. Okay? Wouldn't be a jury trial. But you're waiving the right to go to a full-blown evidentiary trial. Do you understand that?
Yes.
An evidentiary hearing?
Yes. Sorry.
It is technically a trial, but we call them an evidentiary hearing. It's not a jury trial.
Yes.
And that would be by a bench. But you're waiving the right to do that. That's a constitutional right, to force the state, to prove their case, in this case, by a preponderance of the evidence in a VOP. But that's your right to make them try their case. You're saying, no, I don't want to do that. I want to go right to sentencing. Is that what you want to do?
Yes.
And based on what you're getting from that is you're getting a cap. So something they can't go above the minimum guidelines that are contained in the score sheet. Is that your understanding of everything?
Yes.
And you've gone over with your attorney what the score sheet means and what minimum guidelines mean and how that all works?
Yes.
Do you have any other questions regarding this plea agreement?
No, Your Honor.
Okay. And you believe this is in your best interest to enter into this plea?
Yes.
And, Your Honor, just another finesse point on that. This is only on incarceration. As I explained to Ms. Gravani, the court has discretion upon probation of any length. This doesn't cap that.
That is true. That is true. It doesn't say that in here, but that is important that you do understand that the incarcerative sentence, it would be up to the maximum of the total, which in your case these are both significant charges, so they would be open to very lengthy probation if the court so chose to do that. Do you understand that?
Yes.
Can you have a lifetime of probation? I don't think
You can, Your Honor, but if
I've
we were...
never heard anybody ever doing that.
Yes, Your Honor, we didn't anticipate the court likely doing that nor asking for that at sentencing, but I did tell her that it could be...
Could be a lengthy,
a lot longer than she was currently on.
Okay.
Question? And the state's, you already said you're...
That's correct.
Okay, so based upon all this, your testimony here today, the court will accept your plea. You were previously adjudicated guilty. You're fleeing to the court. So there will be a resolution of the front end, but the sentencing will have a cap on it of 57.15 months in the DOC. You'll get credit for all time served while you've been incarcerated for this. And that'll be on both cases, but they will run concurrent. And you will be not liable. There is the possibility of substantial probation in addition to any incarcerative sentence. The court might, if the court does do it. Okay?
Yes, sir.
Okay. Thank you.
And
you
as
want
I
to do a TBD
yes,
on
Your Honor.
that.
I explained that to Ms. Gravani. We would have to schedule that with the court. My anticipation is that probably an hour, if not a little longer, depending on witnesses.
I agree. If you'll call my judicial assistant and get that scheduled.
Yes, Your Honor.
Who has K's? K's? Brandon Lee, Kendrick, not Tyler Dean.
Yeah, we did Brandon. Tyler's on the afternoon.
That's out of custody. Well, you just sent that back. You
You good, Steve?
Mr.
Yeah.
Medina, you on?
Your Honor, I can do roughly half of my inmates now.
Okay,
if that's
let's do it.
Your Honors, before the court is Daniel J. Askew. Mr. Askew's case is 19 CF 3283. I apologize, I don't know the docket number.
Now I've got 19 CF 3282. Trying to make sure we got the right. This is an add-on, Madam Clerk.
Yes, there was a time. It's my bad. It is 3282, Judge. I wrote the number down incorrectly on my cheat sheet.
That's all right.
Your Honor, the state is the reason why we're here today. It was a status because I got a Keaton acceptance late last week, but I've discussed it with Mr. Askew. He's not prepared to accept Keaton because he's been advised that it would very likely come with an accompanying probation sentence that would send him out to supervision, and he's not wanting to do supervision. The state has indicated that it has a guidelines offer and was not willing to do 9 months jail, but was willing to do bars to bed Keaton. So we're going to need to continue it at this time. It will not be set for evidentiary hearing at this time.
Excuse me.
Yeah, Your Honor, Mr. Askew, upon hearing more details, does want to do bars to bed Keaton. I've explained to him it typically would come with a 36-month probation sentence. However, there is a statute that does allow early termination if there's been successful compliance and no violations at the halfway. If he's completed at least half, it's discretion of probation of whether to do early terminate or do administrative non-reporting. He wasn't aware of those possibilities, and so if we can set him aside, I'm going to write it up, and I think that's what he wants to do. Is that what you want to do? Thank you, Your Honor. I apologize.
Okay, we'll come back. We'll get it buttoned down.
All right. Thank you.
We need to write it up.
Yes, Judge.
I think because the rest of this we're downstairs later on.
What's your next one?
This is Mr. Bayless, Your Honor.
Okay.
Your Honor, we have an agreement for Mr. Bayless. It's Jonathan S. Bayless before the court, docket 33. It's case 21 CF 2102. And I'm pulling out the score sheet and making sure he's seen it, Your Honor. We have an agreement. You knew that was your score.
Yes, sir.
And he is signing the agreement, Your Honor, that we've been over.
Thank you. All right.
May I approach with the agreement and the score sheet, Your Honor?
You may.
I'll lit up on my phone.
Thank you. You're okay with the score sheet?
Yes, Your Honor. May I have just a moment? I've got several agreements on my phone here.
Okay.
Okay. Except for his, Judge. I'm sorry. Can I make a copy of that?
Sure.
I apologize. Thanks, sir. Thank you.
We're probably gonna have
Sure.
As you can see, Your Honor, we were going one way with this, and then Mr. Bayless elected to go ahead and resolve it another way that's in the agreement before the court. Under this agreement, Mr. Bayless will be able to continue his probation. He will not be able to do bars to bed Keaton. However, there is a statute that does allow early termination if there's been successful compliance and no violations at the halfway. If he's completed at least half, it's discretion of probation of whether to do early terminate or do administrative non-reporting. He wasn't aware of those possibilities, and so if we can set him aside, I'm going to write it up, and I think that's what he wants to do. Is that what you want to do? Thank you, Your Honor. I apologize.
We're
Mr. Bayless would be changing his, we're going to resolve a misdemeanor case. It's a BUI case, a new law, 23 MM 3273. And that case would be resolved along with the felony VOP case 21 CF 2102. There would be 12.1 months DOC. He's admitting the violation. He was previously adjudicated guilty in 21 CF 2102. He will be adjudicated guilty as charged in the 23 MM 3273, which involved a BUI misdemeanor and a refusal to submit to BUI test misdemeanor. He will have 12.1 months DOC with credit for all time served in 21 CF 2102. There will be concurrent 11 months, 29 months. So it's, 11 months, 29 days probation, incarceration, concurrent between all cases and counts in 23 MM 3273 with credit for all time served. And I did not.
Let me ask you this, but there's one, the maximum on the BUI, count 1 of 3273 is only 6 months. So we should probably.
I need to change that, Your Honor. You're absolutely right. I apologize. That was, right. I did not pick that up. And may I also ask, Madam Clerk, can you tell me, please, what the BUI cost would be on a misdemeanor BUI case?
So the maximum sentence you're getting is the 12.1, but the two misdemeanors, they're separate charges.
Yes, sir.
You can only, you can't be sentenced beyond your maximum. So the maximum of one of your misdemeanors was 6 months. So you're being sentenced to 6 months out, and the other one was 1 year. So that's the 1129, but they're all done concurrently. So it's the 12.1 that's really going to drive this primarily.
Yes. Yes,
and you will get credit for time served on all of them.
Okay.
So it's 1129 incarceration on count 2 of the misdemeanor case, and then there's an asterisk, or there will be an asterisk, 6 months on count 1 incarceration.
Okay.
May I approach Judge? Thank you. And Madam Clerk, did you have that for cost of the BUI case?
Is the state seeking a fine?
Yes, ma'am, there is a $500 fine. And, you know, I probably skipped over that when I was reading. There's a $500 fine in 23 MM 3273. There's $100 VOP fee, $200 total PD fees, including the $50 application fee. And so, yes, ma'am, the state is seeking a fine in the BUI case.
All right. I have a total amount of $990. The costs are $465. Then when you tack on that $500 fine, you get a 25% surcharge.
So I've $990 I've inserted, Your Honor. Thank you.
Very good. The state in agreement?
Yes, Your Honor, that is the state's agreement.
Okay. So, Mr. Bayless, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So we're resolving both your 2-count misdemeanor as well as your violation of probation on the felony charge. And a lot of talking going on. I just want to make sure all this is contained in your written plea agreement. Did you read this closely and go over it with your attorney?
Yes.
Had all your legal questions answered?
Yes.
You understand you're getting sentenced to different things based on your charges?
Yes.
Misdemeanors are sentenced to lesser time than the 12.1, but it's all being done concurrent.
Okay.
So the thing that's going to drive it is the 12.1. Yes, sir?
I'm not sure I wrote the words revoke and terminate on there.
No.
May I?
Yeah, go ahead.
I apologize.
It's all right. I'll continue to. So I just want to make sure you understand that by entering into this is the final resolution of your cases.
Yes, sir.
No trial. You're waiving the right to go to a trial.
I understand.
Valuable legal rights. You've gone over it with your attorney and all your legal questions answered.
Yeah. The only other question I was wondering is the probation, is that the original date, or is that Is that done?
You-
Is that
you-
completed with this?
Revoke and terminate supervision.
Okay, gotcha.
So that means you're terminated.
Okay,
You're
the time
being
will-
sentenced to
The time.
your incarcerative sentence, with all the credit for time served, that incarcerative sentence is done.
Okay.
And
Once you're finished with that, you're done. You don't come back on probation.
Your Honor, I'm adding a separate note, if the state's okay with it and the court's okay with it, 12 months to pay outstanding monetary obligations upon release. So you'll have some additional time when you get out before it goes against your license.
I understand.
Any questions?
I think I understand.
You do have 30 days to appeal this.
Yes, sir.
Madam Clerk, was there a problem?
I'm concerned about the amount on that refusal. You know, as with the criminal traffic, there's a $500 penalty for refusal.
Well, I'm only aware of the BUI fine was a minimum mandatory $500, so that's all I've included.
Yes, sir.
May I approach? You saw that?
Yes, sir.
Thank you. Very valid.
That's all right. Mr. Bellis, any questions?
I think I understand.
Good luck. All right, man. You're good.
All right, thank you.
Would you announce the case, Mr. Medina?
Yeah, I'm sorry, Judge.
Thank you for that.
We've got two Bertrams, and I just wanted to make sure I had the right one. Your Honor, Steve Medina with Daniel B. Bertram. So it's docket number 3423 CF 2000. And at this time, we're going to proceed with a bond hearing, Your Honor. I thought we might be able to work it out, but basically he had filed a pro se motion requesting a signature bond, and I adopted that. I don't normally do that, but I did review it and felt it was appropriate to go ahead and file a notice of a hearing and adoption of his pro se motion. I'm sorry, ma'am?
Do you have a copy of that?
Yes, I will let you have my
didn't see it on
copy.
file.
Sure.
And Your Honor, I'm just asking if you had a copy of that because I saw Mr. Medina's motion to adopt it, but I didn't see.
Yes, the clerk provided it to us, but if you don't mind. May I have him sworn, Your Honor?
Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, sir.
Mr. Bertram, what is your full name?
Daniel Byron Bertram.
Okay. You prepared yourself a bond motion. Why is it, without discussing the facts of the case, why is it that you're asking the court to consider allowing you out on a signature bond?
Well, basically, it's a hardship for my family to help raise that money. And long story short, they need me out there. You know, I have a 3-year-old and a 13-year-old granddaughter, and I do have a job. Actually, I have 2 of them. So I'm trying to get back out there and be part of the family and help them keep going as well.
Where are you working?
I work for Miss Sharon, which is a long line fishing vessel. I basically restock it and do all the maintenance on it and keep it clean when they're inshore, and then I work for Sal's Tree Service while they're out at sea.
Where's your boat? Where's the boat located?
It's right behind Harbor Docks, yes, sir, right behind Harbor Docks.
Mr. Bertram, if the court were to consider allowing you out on a signature bond, would you, if the court directed it?
What's the current bond?
Your Honor, the current bond is $3,500, crash a professional on the possession of controlled substance, 3rd-degree felony, signature bond on a petty theft, Your Honor. And Mr. Bertram, if the court allowed you out on a signature bond, would you be willing to get a substance abuse evaluation within 30 days of release to see if you needed any kind of treatment and commence any recommended treatment within 60 days? If you did need any?
Yes, sir. If that's part of the stipulation, I wouldn't have a problem.
Okay. Have you ever had any failures to appear? It looks like to me they wrote one in 2018. Do you remember anything about that?
Yes, I had the wrong month on my court date.
Okay, so it wasn't anything intentional and knowing on your part? Okay. Anything else you want to tell the judge, to ask the judge to please consider?
I just asked you to consider this, sir, so I could be with the family and try to help them, basically for my youngest granddaughter, and stay active with my employer. I appreciate your time and consideration in that matter.
What's the state's position?
Your Honor, and I'm sorry, I don't think I heard what the defendant's actual bond request
It was it's $3,500. He's requesting that be converted from cash or professional to signature on the possession of controlled substance. He already has a 1,000 signature bond on the petty theft.
Your Honor, the state wouldn't oppose the court reducing the cash or professional bond slightly to something less than $3,500, but the state is requesting a cash or professional bond in pretrial services. Mr. Bertram has a prior sell, manufacture, deliver. He has 6 prior possessions of a controlled substance. He has a prior resisting without violence and a prior battery on a Leo, Your Honor, and 16 prior misdemeanors. So the state is a little bit concerned about him continuing to pick up new charges.
Nothing further, Your Honor.
What is the state? You said you're not opposed to lowering it. What is the state's?
$1,000 to $1,500, Your Honor, is what state believes would be appropriate cash or professional bond for this.
Court lower it to $1,500 cash or professional on the count 1 in the possession of a controlled substance with the pretrial condition of a substance abuse evaluation within 30 and start any treatment in 60 days that's recommended.
Is that with pretrial services as well, Your Honor?
That's correct.
Thank you, Your Honor.
And Mr. Bertram, you got to, get on top of this. You're running out of rope on this. You've had multiple times. They're going to be looking to put you away if you don't get this straight. It's up to you. We believe we got plenty of people in jail. We don't need more people. We'd like to see you out working on your boat, taking care of your family.
Thank you.
Your Honor, may I ask the court, should he remain on the December 13th docket just in case he doesn't bond out? Okay.
Thank you.
Thank you, Your Honor.
David?
Your Honor, David R. Bertram is before the court. Mr. Bertram is docket 35, 22 CF 1638 and 22 CF 3135. At this time, Your Honor, I am asking for a continuance. I'm not asking for an evidentiary hearing at this time, basically it is a VOP case with a guidelines offer, and we're going to discuss it some more.
I got something I'd like to say.
We'll continue this matter till 12/14, 9 a.m.
I can't speak, Your Honor.
I don't know. What
Your Honor,
we don't really have anything before the court. What do you want to speak?
Well, I'd like to say that I've written my public defender several times on this matter, that when I was checked into probation, the probation officer that did my intake told me...
You're contesting your VOP. Talk with your attorney. Let's get this thing set for a VOP hearing.
I thought this was, Your Honor. I'm sorry.
That's not what it is.
This, Your Honor...
If you want to set a hearing, that's fine.
We can set it for a VOP evidentiary hearing to be determined.
Very good.
So we will get with the judge's judicial assistant to set a VOP evidentiary hearing date. Thank you.
Right, this way, sir.
TJ, can we get, Mr. Owen only has one case. Can we get?
Oh, Natalie Belch. Is it Natalie Belch?
Yeah.
I think he needs to speak with her first.
You need to speak with her, Mr. Owen?
If you're involved in other cases, yes, I'd like to.
We're still got, unfortunately, we've got a few left, so go ahead.
I'll speak to her.
I thought you were waiting out there, and now you only had one case, so get it out of the way for you. Go ahead, Mr.
Your Honor, Steve Medina with Christopher Ralph Bobbin. He's docket 36, 21 CF 917, 21 CF 993, 21 CF 152, 23 CF 657, and 23 CF 667. And we have an evaluation pending. I believe the state is willing to keep its offer open until we get the evaluation from Dr. McDonald and go from there. If we can do roughly a 1-month continuance, we should have her evaluation and make a decision by then of which way we're going to go.
Very good. So we'll continue this till December 14th at 9 a.m.
Thank you, Your Honor. Under Steve Medina with Spencer Bodiford, docket 37, 20 CF 1516 and 20 CF 1517. The state has offered to allow him to plea to the bench with a 12.1 months cap. At this time, we're going to ask to continue the case so we can assess what option he wants to take.
So we'll continue this till 12/14 at 9 a.m.
Thank you.
Did your client leave anything on the phone?
I got just for the record, I got a page, one paper from Mr. Bobbin that was Master's Touch acceptance form. That's the only piece of paper. Not to my knowledge, sir.
Okay. Spencer Bedford? No? Bradley? Where's Bodiford?
That was Bodiford we just had, sir.
Never mind.
He was wearing the stripes.
Thank you.
Yes, sir.
Faster than you think.
Yeah. So did you have Bradley or did you start testing for Gates and he's going to do this? We'll probably do that question when I do Mr. Gates' last one.
Hey, TJ, do we still have Mr. Gunnels in the building?
Yeah, I think so, because we got to get his address.
We can bring him up, back up.
We're under Steve Medina with Eugene Q. Bradley,
Trying to get it now.
docket 38, 22 CF 1274, 22 CF 1940, 23 CF 473. At this point in time, Your Honor, we don't have a resolution. I'm explaining that there is an option if he wishes to contest the VOP that basically involved him leaving without successfully completing Keaton, that we could set it for an evidentiary hearing as to the situation, but I don't think the court will have an evidentiary hearing today.
Your Honor, may I I won't take much of your time.
And I just wanted
It can't be
to,
resolved. We don't have it scheduled today.
may I just raise one thing, is his father passed away about 2 weeks ago, and that was, I think that's just a very emotional time for the family.
That's the reason why I left the program, so I could see my father one last time. And
Sir, you need to do that. You need to raise this issue in a formal hearing. We're not here on that.
I don't know how.
I'm not discounting it, and I'm certainly not downplaying it, However, we don't,
Yes, sir.
we got 50 cases this morning, and we want to give you the time you need to really lay it out there.
Is
So-
there, if I pled out to you today, if I pled to you today, to the mercy of you, sir,
You mean a plea to the bench? I don't understand. If you want to talk to your attorney some more about it.
Your Honor, I think that the court's position would be if we did do a plea to the bench with something like a 12.1 month DOC cap, which the state might agree to, it would probably be set for sentencing at a later date would be my concern. I don't think the court would sentence on
I
this.
would very much rather not, because they have not been lenient toward me at all in my life period. I'm going through a serious situation. I would like to speak with you, sir, in a plea. I understand that I scored 9 months, and I would.
Well, the thing is that.
Like
I don't understand what you're asking.
Yeah, and I've been told by my attorney that the state won't even agree for me to go to my father's funeral. So I don't know what to do about all this right here. So on my heart, I just feel like
don't. This is not an emotional.
Yeah,
thing.
no, I know. I'm not using my emotions. I'm just using what knowledge.
It won't be helpful.
Yes, sir. I understand. I would prefer, to speak with you about my sentencing.
When?
Your Honor, the funeral is November 27th. Assistant State Attorney is not willing to agree to a furlough. I've asked her, and so we don't have a stipulated furlough.
Okay. I'm not sure.
I don't know.
Sounds
if
like he's wanting
if
to plead to the court.
Your Honor, if I am speaking for him, I've already spoke, and we'll set it for a VOP evidentiary hearing. If he wishes to relieve the public defender, Mr. Bradley knows I'm doing my best for him, but I'm just not getting the results that he feels like he needs.
Because we don't have the results because you don't communicate with me. You wait till I come to court. So I just want to plead to the judge, at the mercy of the judge at the bench.
Well, it's not going to happen today for sentencing.
It's all I can do, sir.
Yeah. Okay. Your Honor, could the public defender be relieved? If that's what he wants?
If you file something, you do, but not for today.
Okay.
So we'll come back on 12/14. If you want to set it for an evidentiary hearing, talk to your attorney. You're going to communicate with him, Mr. Medina, if he wants an evidentiary hearing or a plea to the court?
Well, Your Honor, because of the family situation, is there any way we could continue him to next Tuesday, the 21st, to come back? Okay. All right. So 12/14 will be a not evidentiary hearing at this point.
Unless you want to substitute and you have to give some other time, which you can set it with my judicial assistant.
I think at this point in time, so we can move things along, that I would ask rather than a 12/14 that it be to be determined and set for VOP evidentiary hearing.
Very good.
Thank you. Your Honor, Steve Medina with Stephen C. Briley, 18 CF 2259. I filed a motion for a bond for him. However, I think we're going to be able to reach a stipulation based on talking to the court. This is a very old probation situation. I'm sorry if I didn't announce the individual, but it's Stephen C. Briley, docket 39, 18 CF 2259. I was hoping we could work out a time served deal, but basically the state is willing to stipulate to him being released on a signature bond on there are 4 third-degree felony counts. Would the state agree to $1,000 for each one for a total of $4,000 signature bond? And then we could put them on a 12/14 date. You'd have to come back December 14th at 9 a.m. and he could try to get his restitution and other monetary obligations paid off in the meantime.
I can do that.
The state would agree to that.
Very good. The
Your Honor.
court will agree to the stipulation of a bond reduction, and all 4 counts will have a $1,000 signature bond, so that's 4 times $1,000, all signature bonds. And we'll continue to come back on 12/14 at 9 a.m.
Yes, sir.
And be in communication with your attorney in the interim, try and get this thing worked out, you know, the fees and stuff.
Yes, sir. Thank you, Your Honor.
Okay, so
Calm.
Appreciate it, Your Honor.
Thank you, Your Honor.
Rhonda, do it.
Yeah, in here.
Do it. The lectern.
Your Honor, I have some information from Ms. DeWitt I got this morning. May I have just a moment with her?
you may.
Thank you.
Okay.
May I just make sure on the record, this is Rhonda M. DeWitt, Your Honor, docket 4623 CF 688. Ms. DeWitt had proposed a time served deal. The state represents that perhaps she only has about 3 months in jail and isn't willing to do that. She is asking if she could reinstate to basically some sort of reinstatement, and I'm not sure the state is willing to agree to that.
I can look at it, Judge, if we want to pass her or bring her back at 1:30, if the court's okay with that. Otherwise, I'll need some time, more time with that.
I mean, why don't we go ahead and schedule her for 12/14 for her to come back, but if you all can get it resolved, to come back and bring her back at 1:30 and we'll get a plea done.
I think that's fine.
So you can get it done today. If not, it'll automatically roll over to 12/14.
Okay, thank you, Your Honor. If the jail, if staff can hold her to the afternoon, then we'll advise. Thank you.
Otherwise, 12:14.
JJ, Rhonda
Yes.
DeWitt's going to be needed back at 1:30.
Thank you.
Elizabeth.
Yes.
Would you announce the case, Mr. Medina?
Yes, Your Honor. Steve Medina with Elizabeth A. Dills, 23 CF 2313. Ms. Dills is docket number 47, and we're here on a bond motion at this time, Your Honor.
You may proceed.
Your Honor, could Ms. Dills be sworn?
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Counsel.
Ms. Dills, are you able to pay a $3,500 cash or professional bond?
I'm not. Not at this time.
What is the most bond that you could pay, or are you unable to post any kind of cash or professional bond at this time?
I don't have anything even at the jail with me. Everything that I have is back in Fort Walton with, I hope, my belongings.
Are you asking for a signature bond?
I am. My dad is in Ohio. My dad resides in Ohio, and he's the only family that I have down here. Although I have lived here for almost 10 years now, I finally have 2 jobs, stable housing. Everything is actually going really good in my life right now. Everything's going really good. I finally have an income to where I'm able to meet the demands of everything else. Any trouble that I've had to pay off my driver's license, to get that reinstated, along with my vehicle insurance. Everything is in a trajectory on exactly the right path.
You have 2 children, is that correct?
I have 1 birth child.
Okay, but they're grown, right?
Yes.
Okay. Is there anything else you wanted the court to consider about why you believe you need bond? For instance, do you need to keep your job with PTG Tree?
With PJG Tree, yes. And also, I really would like some more time to work with you on this case because I'm not a felon, I'm not a violent offender, I'm not a felon, and I would really like to have time to.
Right, Your Honor. I was seeking
I've already been.
Excuse me.
Sorry, pardon.
That's okay. Your Honor, I was just so the court's understanding, she has a 24-month probation deal. I was trying to, she's on the docket for the afternoon. If she doesn't get bond, then she's already on the afternoon docket, and we can see about resolving the case. The state wasn't willing to do a misdemeanor paraphernalia.
She's on the afternoon on the arraignment docket?
Yes, Judge.
State, what's the state's position regarding the bond reduction?
Your Honor, the state would stipulate to a signature bond, but with pretrial services. She does not have any previous possession of controlled substances.
Thank you, correct. That's right.
Very good. The court will grant the reduction to a $3,500 signature bond with pretrial services. And what do those pretrial services entail, counsel?
Your Honor, is the state requesting substance abuse evaluation within 30 days and commence any recommended treatment within 60 days?
Okay.
And I think it's level A, Your Honor. It's reporting pretrial services, but I think it's once a month reporting, I think.
Your Honor, I do want the defendant aware that this court is not addressing, I think she has a misdemeanor case with an FTA, so I don't know what her next court date is on the 22MM3402, but that is not being resolved today.
But is she in jail on that one as well?
It's my understanding she has a 2000 cash professional in that one.
If I may, sir. Now, when I was here last week in front of Judge Schlechter, I asked the public defender 3 times if I was being held on that, because she said we could do a continuance, and I said yes, so that I could work with my felony, because this is it's a confusing case here, and I've never had it where I have to have 2 attorneys, so I'm just very, very confused on that, and I haven't had time to speak with anyone. I know you guys are so busy. We're so overcrowded in the jail as well. That's what they told me that I was only being held on my phone. That's what they said on.
Your Honor,
what's the state's position? What's the state on?
Your Honor, I do know that she had a misdemeanor, and I am looking.
What's the misdemeanor charge?
I know that I don't recall, Judge, I'm looking. I know that it was a return from a pretrial version.
It was a DPA recall with an underlying charge of paraphernalia. Basically, I did look into it. There was no information filed in 22MM3402, so it was going to be impossible to do a global plea with Your Honor today that would encompass the case with no information.
Your Honor, my colleague stated Miss Gaynor did respond to Mr. Medina and stated that the information was filed on September the 12th.
Okay.
So there is an information filed, and the state's offer included that misdemeanor case, which if I did send Mr. Medina over the offer for this case, if she wanted to take that offer, then it would result in her release from jail because it was a probation offer.
Your Honor, could we have her come back at 1:30? I'll write up the agreement. That's what she wants to do, but it's for 24 months probation. So is that what you're rolling it into that? Okay, so you have a 35, but she doesn't have a bond in that FTA case. That's the underlying point on it, while she's going to be incarcerated.
So if we resolve
ma'am, you can come back.
If we resolve the misdemeanor.
Resolve the case, but you're taking a felony charge, 2 years probation. Yeah, the misdemeanor would be rolled in 1129 concurrent probation.
Well, this was just a adjudication court cost, is what Rachel offered.
So you'll be able to resolve this afternoon. Yeah. We'll keep her this afternoon, Judge. I'm sorry for all that.
Okay.
JJ 41 Elizabeth Dills.
So you'll come back at 1:30 and we'll write it up. Thank you.
Thank you. Thank you, Your Honor.
Oh, they're gonna do eye testing and we're gonna do
This.
Or do you want to go ahead and do that 12? Then we're gonna do the rest of the week.
Your Honor, Steve Medina with Jerry L. Estopinal. Ms. Estopinal is docket 4821 CF 2932. And she is signing a violation of probation agreement that will involve a plea to the bench.
Mr. Gates and the court request to make a search for probation.
And Your Honor, because it's a plea to the bench, the score sheet would be provided at a future time. May I approach?
You may.
Your Honor, Ms. Estopinal was before the court roughly a month ago, and she had a 12-month DOC offer that was the state's position if she did not want to be, if she did not want to do drug court. I sent the drug court representative to speak with her, and the decision was made she did not want to do drug court. However, she does want to, as an alternative, rather than becoming a convicted felon and going for DOC of 12.1 months, she is wanting to plea to the bench. So this agreement would have her pleading to the bench with a cap of 12.1 months DOC with credit for all time served. And of course, because the court has jurisdiction over the second degree felony, there would be no cap on supervision. However, she wanted the court to be aware, and we already made the state aware that she does not want to come out to supervision. So she's really just trying to see if the court would do something that would basically be a jail sentence and allow her to keep a withhold.
Okay. Okay, I mean, I don't know what to say. You're putting the defendant's wishes in the plea agreement.
Just so
you understand, ma'am, the fact that you don't want to come out to supervision doesn't mean that's what's going to happen. But he's saying it's in here. You can argue it. You can argue anything you want if you go plea to the bench. Is this a downward departure? Is the 12.1 the minimum guidelines? What is
No, Your Honor.
No, Your Honor. She does not score 44, so this would be within the 12.1 would be within the guideline. She doesn't.
Was
She
it
doesn't.
underlying second degree felony?
Yes, because she has
She didn't have any priors.
No priors. It was just basically 28 for the primary offense, and then
6 for technical.
then the second violation with 12 points. So a total of 40 points on the state score sheet. Correct.
Okay. Very good. Mrs. Stopino, would you raise your right hand? Just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
The state is in agreement on this, yes?
That's the state's agreement.
Okay, so you heard your attorney state the terms of your plea agreement. I see you've signed the written plea agreement that contains this. It's a plea to the bench. with a cap, an upper limit cap, 12.1 months in DOC. You will get credit for all time served. That's the cap. The court can go from 0 to cap, full cap. You understand that?
Yes, Your Honor.
There is, I'm sorry?
Yes, Your Honor.
Okay. And you do understand that even though you don't want to come out to supervision, there's no agreement about supervision.
Yes, Your
The court could technically go all the way up to 15 years. That's your maximum. And it probably wouldn't happen on probation. But I'm not prejudging it here, but I'm just saying you can come out to some probation. You understand that?
Yes, Your Honor.
Okay. You understand that by entering into this plea agreement, plea to the bench, that you're waiving the right to go to a trial. This will be a final resolution of your case other than the sentencing. Do you understand that?
Yes, I do, Your Honor.
And is this, is there agreement with regards to adjudication? That's with the discretion of the court.
I think I marked it for discretion of the court, Your Honor.
You did. And that's an important part, obviously, what's going on. Well, you can argue that when you, at the sentencing agreement. So, but you do understand that you're waiving the right to go to a trial.
Yes,
waiving some other valuable legal rights. You've had all your legal questions answered by your attorney?
Yes, Your Honor.
And you believe this is in your best interest to enter into this plea agreement?
Yes, Your Honor.
Okay. Very good. The court will accept your plea. It will be a plea to the bench with the cap, 12.1, credit for time served, and there will be no cap on supervision. Okay. Then we will come back on the sentencing to be determined as far as the date. Got to get with judicial assistant to do a sentencing. Okay?
Yes, Your Honor.
Thank you.
Thank you.
You ready to go, Mr. Owen?
I am.
Can Mr. Owen do his one case?
For number
Mr.
10, Natalie Belcher. You can also put Brandy Jones in with you. Natalie first, you go left one.
Judge, good morning. I appreciate you letting me appear late. My name is James Owens. This is Natalie Belt. She's here for a VOP. I just got retained on the case. I believe you signed the order substituting counsel on October the 26th. I need some more time on the case. I'm asking it be passed.
Very good. So we'll continue this until 12/14 at 9 a.m. That's without subpoenas, so we're not going to an evidentiary on that one. But we'll probably, now if you have a month, you can assess it, and we can schedule something at that point, or figure out where we're going with it.
Yes,
So
thank you.
that is, I just wanted you to know that's not an evidentiary. That's without subpoenas on the morning of the 14th. Okay?
Okay, thank you. Judge, I have a hearing with you this afternoon, Shay Jones at 2:30.
Yes,
I have docket day in Santa Rosa County with Judge Drake, with Judge Duncan. I'm not for sure which one. Do you have a full docket so that I can appear a little later than 2:30?
Well, I do have a full docket, but we purposefully let you go first because I've got the docket at 3 and 4 o'clock, so we don't have any space at the end.
Okay,
we reserve the space for you at the beginning.
All right, I'm going to come first here, and then I'll just go to Milton afterwards.
The only problem, though, let me warn you, we've got a heavy arraignment docket at 1:30. Now, you're scheduled right now for 2:30. I can't promise you that we're going to start right on time at 2:30. I don't want to put you, I apologize. I mean, we're trying our best to get all the cases in on this. But
I understand.
Arraignment is a heavy arraignment. We can't control the arraignment docket. They just automatically get dropped in there. I think we've got 40-some arraignments in 1 hour.
Do you anticipate starting about 2:30?
I think we're going to struggle to get all 40 cases in 1 hour yet. I don't know that we'll start right at 2:30. I'd say, I don't know, 2:33. I'd say, if I were guessing, I would say 3. What do you say, Mr. Gates?
I would say more likely around 3 to 3:15.
Yeah.
Okay. Thank you, Judge.
Okay, so you gonna be able to come back?
I think I'm just going to stay here
Okay.
and wait around, get some lunch, wait around, and just and then go over there and do that.
Okay.
I think that's the best thing, unless I change my mind. But
Well, just let us know.
thank you.
Yeah.
Let me come around and.
Your Honor, if I can take my two out of custody first, I'm going to start with Parker Gurria.
What number is that?
Mr. Gurria, I'm on the wrong page here, Your Honor. Back to the front, Mr. Gurria should be number 16 on the docket, Your Honor.
Got it.
You know, we have a plea agreement to be filed in Mr. Gurria's case. It is going to be a modification, so a score sheet will not be necessary, if I may approach.
You may. Thank you. Would you please announce the plea?
Yes, sir. Mr. Gurria will be admitting the violation before the court in 20 CF 2010, 20 CF 2356, 21 CF 2985. He was previously adjudicated on all counts and cases. In 20 CF 2010, we're going to modify and reinstate his probation. In both counts, he'll be extended by 6 months past his current termination date, complete the original requirements, automatic early termination upon the completion of all outstanding requirements, a standard court cost or cost of prosecution PD fee. In 20 CF 2356, modify and reinstate probation, again in counts 1 and 2, which are felony, extend probation by 6 months from current termination date, count 3, which is misdemeanor time served, complete original requirements, automatic early termination upon completion of those outstanding requirements, center cost of prosecution, PD fee, and then in 21 CF 2985, we're going to revoke and terminate his outstanding probation. It is a misdemeanor case, it will be time served, $100 cost of prosecution, $100 public defender fee, and then Mr. Greaves asked for 24 months to pay those outstanding fees.
State.
That's the state's agreement, Your Honor.
Mr. Gurria, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
You heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement. Have you gone over this? First of all, have you read this closely?
Yes, sir, I did.
And you gone over it in detail with your attorney, make sure you understand the legal ramifications?
Yes, ma'am.
Okay, you understand that by entering into this, you're waiving the right to go to an evidentiary hearing, a trial? And this will be a final resolution of all these violations of probation. You understand that?
Yes, sir.
You believe that's in your best interest?
I do.
Okay. You've had all your questions answered?
I have.
Okay. Based upon that, the court will accept your plea. And as stated, previously adjudicated guilty on all these counts. On 20 CF 2010, modify and reinstate, extend by 6 months, early termination upon the completion of the requirements, same fees and costs of $100 and $150. On 20 CF 2356, basically identical, except that count 3, which is a misdemeanor, you get credit for time served. It's identical to 2010. You're extending the probation by 6 months with the current termination date. And then the last one, the misdemeanor 2985, revoke and terminate, credit for time served, and then fees and costs. You'll have 24 months to pay the outstanding court costs before they're sent to collections. Okay?
Yes,
Any
sir.
questions?
Yes, sir.
Good luck.
Thank you.
Our next I've got is going to be Renee Heinrichs. Ms. Heinrichs will be my last out of custody. Ms. Heinrich should be number 23 on this morning's docket, Your Honor.
Correct.
If we can continue Ms. Heinrich's VOP without subpoenas to the December docket, Your Honor.
We'll continue this till December 14th at 9 a.m.
Thank you, Your Honor.
Thank you, gentlemen.
If I can write that down for Ms. Heinrichs, Your Honor. Your Honor, this is going to be Brandy Jones. She's on this morning's docket as number 24. She's also on the arraignment docket this afternoon, Your Honor. Make sure I get the right number. On the afternoon docket, she is number 33.
Okay.
This time we are going to be withdrawing the bond motion and instead entering a plea. I can have Ms. Jones sign the plea agreement, Your Honor.
And you're doing both the old and the new charges?
We only have, there's only the new charges, Your Honor.
Right.
We noticed her for the bond hearing this morning.
Correct. That was on the bond here, was on the one charge.
May I approach?
You may.
The state will be providing a score sheet later, Your Honor.
That's correct, Judge. Ms. Hyrix entered a plea early in the case. I need to produce a score sheet, however, it is not a downward departure.
Very good.
The state said Ms. Heinrichs, but it's actually Ms. Jones, Your Honor.
I apologize, Ms. Jones.
That's okay.
And counsel, would you please announce the plea?
Yes, Your Honor. Ms. Jones is going to be entering a plea no contest to the information in counts 1, 3, and 4. In exchange for the no contest plea, the state's agreed to dismiss count 2 of the information. She'll be adjudicated guilty. Count 1, which is the felony count, 24 months of drug offender probation, waive the cost of supervision, and counts 2 and 3, which are misdemeanor, time served. Her curfew will be from 10 p.m. to 6 a.m., can be modified by parole and probation for work purposes. Standard court costs, public defender fee, required to do a substance abuse evaluation within 30 days, any recommended treatment within 60 days, random urinalysis, and Ms. Jones is entering the plea without the opportunity to review discovery, including any sort of FTLE reports, and the state's agreed to dismiss count 2.
That's correct, Judge. And I did look, I have produced a modified score sheet that removes count 2. I believe she scores 41.4 points, so this is not a downward departure.
It is not a downward.
It's not a downward.
It's not. Very good. Okay, Ms. Jones, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement, and I see those same terms are in the written plea agreement that you've signed.
Yes, Your Honor.
And I see that the written plea agreement's all marked up, which indicates to me you've probably gone over it in detail with your attorney.
Yes, Your Honor.
And you've had all your legal questions answered about this plea.
Yes.
You understand, importantly, by entering this plea agreement, you're waiving the right to go to a trial.
Yes.
And you're actually waiving several of your legal rights in order to get a final resolution. Do you understand that?
Yes, Your Honor.
Okay, you believe this in your best interest to enter into this plea agreement?
Yes.
Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on counts 1, 3, and 4. Court is agreeing to dismiss count 2 in exchange for this plea. In count 1, court will sentence the defendant to 24 months drug offender probation, waive the cost of supervision. In counts 3 and 4, you'll get credit for time served. Those are both misdemeanors. Curfew on your drug offender probation will be from 10 p.m. to 6 a.m. and you may be modified by parole and probation for work purposes. You've got fees and costs. Importantly, you must get a substance abuse evaluation within 30 days and start any recommended treatment within 60 days and follow up with random UAs. And you understand you're entering this without the ability to review discovery. Do you understand that?
Yes, Your Honor.
Including any FDLE reports. And there'll be a an adjudication of guilt on counts 1, 3, and 4. Very good. Any questions, ma'am?
No, perfect.
Thank you.
All right, Ms. Jones.
Thank you.
You're welcome.
I'm done now today.
You're done.
Who is it?
Here, this is Miss Sherelle Triplett. She's number 31 on the docket. We have a plea agreement to be filed to cover her case, Your Honor. While she's signing it, just so the court's aware, it does specifically require 25 days jail, and I hand wrote on there that it's the state and our intent that if she hasn't been released by December or November the 22nd, she would be released that day. The state didn't want to agree to her time served the day. We wanted her to at the very least be held until the 22nd.
Of November?
Of November, yes, Your Honor.
And there's no score sheet because it's a misdemeanor.
Yes, Your Honor, that is correct. It's a misdemeanor plea agreement, or a misdemeanor violation, so there'll be no score sheet.
Very good. Thank you. Would you please announce the plea, counsel?
Yes, Your Honor. Ms. Triplett will be admitting the violation before the court. She was previously adjudicated on all counts. We're going to revoke and terminate her probation. 25 days in the Okaloosa County Jail concurrent. Credit will be from November the 1st, 2023. Ms. Triplett's agreed to waive all of her prior credit to that November 1st date. $100 cost of prosecution, $150 above the defender fee, 24 months to pay those outstanding fees. And then I put on the plea agreement, handwritten, that if the defendant hasn't been released by November the 22nd, she would be eligible for release on that date.
I mean, I'm not objecting to it, but
Yes,
it's
Your
like
Honor.
contradictory statement in this, but I'm not quite. And it says 25. It says DOC. You don't mean DOC.
No, Your Honor. I'm reading that. I realized I should have put days Okaloosa County Jail. That's my anagram.
You put DOCJ.
Yes, Your Honor.
So that's the Okaloosa County Jail.
Yes, Your Honor.
But it says you get credit from November 1st, so you got to serve 25 days. So 25 days from the 1st, 25 would be November 25th. But then you're saying, but you got to be released by November 22nd.
That doesn't take into consideration the gain time that she would be entitled to. The
Okay.
assumption is that she would be otherwise eligible for release by the 22nd. But if, for whatever reason, she's not, the state's agreed to say, look, 22nd is the drop dead date. If she hasn't been released, cut her loose at that day.
Judge, can I see it again?
Sure.
And have a moment with Mr. Gates?
So you approach with that, Your Honor?
Sure.
That'll make it easier.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Here, here. Initial next to that nice statement right there. May I approach you with the amended plea agreement, Your Honor?
Sure. So, did you have a question, Madam Clerk?
I was wondering if the misdemeanors had timed out.
She was violated a month prior to the termination of her violation of probation, so technically that's been tolling pending the violation.
Yes, sir.
That's the specific reason. The state's original offer was to reinstate her and extend. I couldn't legally agree to that because she had already passed, she only had 30 days left on probation.
Right.
So this was the other alternative, was to try and get something resolved where it would not be a lengthy deal or jail sentence.
Sure. Okay. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Madam Clerk, did you get your questions answered?
Yes, sir. Thank
Okay.
you.
So, ma'am, you were previously adjudicated guilty, and the court is going to revoke and terminate probation. You will get credit for all time served. That'll be essentially the resolution of these misdemeanor VOPs. You got, of course, always have fees and costs, right?
Yes, sir.
So you will have 24 months from your release in order to pay those fees and costs before they go to collections, okay? So you get credit for time served, you can be able to get out immediately, okay?
Yes, sir. Thank you.
Any questions? Okay, good luck. Counsel, the defense wanted to thank you and accept the appreciation from the defendant, not the defense counsel.